Welcome to this MOOC program on democratic awareness with legal literacy. Today's point of discussion is Article 21, Constitution of India. Two basic rights which inhere in every human being, more specifically two inalienable rights of human beings, are recognized as fundamental right under Article 21, Constitution of India, which states that no one shall be deprived of his life or personal liberty except according to the procedure established by law. This valuable fundamental right has been protected by another fundamental right, that is right to get constitutional remedies, which is protected by Article 32 and Article 226 of Constitution of India. If there is any violation of any fundamental right or encroachment on it, a person can move to Supreme Court under Article 32, and Supreme Court can issue different types of writs for the enforcement of this fundamental right. Similarly, any person can move to High Court also for if there is any encroachment of this fundamental right, and High Court also has a similar writ jurisdiction, and by issuing appropriate writ, it can realize the fundamental rights. So we are finding a second level of protection. But I feel that these fundamental rights and the fundamental right which protects the other fundamental rights, that is with constitutional remedy, this is also protected by Article 13 Clause 1 and Article 13 Clause 2. Article 13 Clause 1 says about pre-constitutional law. So if there is any pre-constitutional law and if it becomes inconsistent with any of the rights guaranteed in Part 3 of Constitution of India, then to the extent of such inconsistency, it becomes void. Similarly, Article 13.2 says that state shall not make any law which takes away or abridges any of the fundamental rights, and if any law is made in contravention of this clause, Part 3 of Constitution of India, then to the extent of such contravention, it would be void. Given this backdrop, we have to find out what is the meaning of the term, what is right to life and what is the right to personal liberty, and whether right to go to abroad can also be protected as fundamental right under the purview of personal liberty. And if it is so accepted and recognized, then it can only be denied by following a procedure established by law. Second fundamental question lies with the fact with this. What is procedure established by law? Does it mean any kind of semblance, or there are some prerequisites, and without those prerequisites, the requirement of Article 21, that is procedure established by law, cannot be satisfied. So to find questions to these very vital, fundamental and constitutional questions, a constitution bench was constituted, and it is a very famous case, Maneka Gandhi versus Union of India, a 7-judge constitution bench. According to renowned jurist Noni Palkhiwala, he says that judgment of Supreme Court in Maneka Gandhi versus Union of India is an important milestone in the history of constitutional law jurisprudence of India. Now, to find the answers to these questions, in Maneka Gandhi versus Union of India, Supreme Court discussed about the importance of fundamental right. Now, unless the importance of fundamental right is taken into consideration, the questions cannot be found satisfactorily. According to Supreme Court, so there are some of the points which have been discussed by the Supreme Court as far as the significance or importance of fundamental right is concerned. First, the fundamental rights find their root deep down in the long struggle of India's independence. According as has been rightly pointed out by noted political scientist Granville Austin in his famous book, The Indian Constitution, Cornerstone of a Nation, that these rights were included in the Constitution with the aim and objective that one day the tree of true liberty would bloom in India in all walks of life: social life, political life, economic life, and cultural life. These rights were indelibly written in the subconscious memory of Indian race, which fought for well nigh 300 years against the British rule for securing freedom for the country. And these rights found their expression in the form of fundamental rights when we, the people of India, enacted, adopted, and given to ourselves this constitution. Secondly, these fundamental rights represent the basic values cherished by the people of this country since Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his or her personality to the fullest extent. Basically, these rights weave a pattern of guarantees on the basic structure of human rights, and these fundamental rights are protected and the dignity of the individuals are fully assured. Number 3, in fact, the entire cultural and philosophical history form the jurisprudential background against which these fundamental rights were enacted in the Constitution, and consequently the conceived by the Constitution makers not in a very narrow limited sense but in their widest sweep, because the basic aim and object was to build up a new social order in India where human beings cannot be mere playthings in the hands of the state or in a few privileged sections of the society. And there would be full scope and opportunity for everyone to secure maximum development of his or her personality to the fullest extent, obviously by recognizing the right to dignity of all individuals. Another point which is very important to be highlighted, that the framers of the Constitution recognized the spiritual dimension of human beings, and they were fully conscious that the human beings were the embodiment of the divinity, where great Upanishadic verse once enchanted that the children of immortality, their basic ultimate objective is to realize the truth, and realization of the truth would not be possible unless people have these fundamental rights like right to equality, right to freedom, right to personal liberty, right to life, right to religion, so on and so forth. So what we are finding, that two important facts are emerging, that these fundamental rights become an integral part to classic India's philosophical concept, and these fundamental rights are actually the integral part to India's tradition, culture, and heritage. So this is one point to be noted, that these fundamental rights have not been given by the Constitution of India. Actually, Constitution of India has recognized these valuable fundamental rights, which find its root in Indian tradition, culture, and heritage. Secondly, the fact which is emerging, that all the fundamental rights are very much important, essential, and indispensable for the all-round development, a comprehensive development of all human beings. It can be in physical development, emotional development, intellectual development, educational development, social development, moral development, etc., etc. So given this backdrop, Supreme Court says that while we have to interpret Article 21, that is, no one shall be deprived of his life or personal liberty except according to the procedure, these high and noble purposes, the rich jurisprudential background based on India's tradition and culture and heritage has to be kept in view. So in that way, Supreme Court says that the attempt of the court while interpreting right to life and personal liberty, so attempt of the court should be to expand the scope and horizon of fundamental rights rather than to attenuate their meaning and content by the process of judicial construction. So basing on that, Supreme Court gave a kind of interpretation, construction of the term expression right to personal liberty. According to Supreme Court in Maneka Gandhi versus Union of India, that the expression personal liberty is of the widest amplitude and it covers a variety of rights which go to constitute the personal liberty of human beings. So with this statement, with this ratio decidendi, the Supreme Court of India, a larger constitution bench, has given a clear message to what would be the nature and content of personal liberty. So it means that there would be some unnamed rights. Those unnamed rights would constitute the named fundamental right, that is right to personal liberty. Similarly, this jurisprudential background, the fundamental right jurisprudence behind personal liberty is also equally applicable to find out, to construe the meaning of right to life. So I can remember that a very famous Supreme Court judgment, Moon versus Illinois. So American Supreme Court says that the right to life does not mean only mere animal existence. Similarly, in a larger constitution bench of Supreme Court of India, K.S. Puttuswamy versus Union of India, Supreme Court says that life, bringing a ought principle into the content, into the nature of right to life. It says that the way life should be lived, and that is to be decided by the social milieu, economic milieu in which those persons live in. So it is a continuous process. It is a continuous process in construing the meaning of right to life and personal liberty, to interpret the right to life and personal liberty in the much larger horizon, that is jurisprudential background and the social eternal jurisprudential background and the change which are taking place in the society. Just a part of recapping the points which are to be noted, that all fundamental rights are primordial in nature because it forms part of India's tradition, culture and heritage, and all fundamental rights are equally important, indispensable for the all-round development of a person. And in that way, while interpreting Article 21, that is right to life, so there are also some unnamed rights which also go to constitute, likely to personal liberty, go to constitute the right to life. So in that backdrop, Supreme Court of India in Maneka Gandhi versus Union of India has developed a criteria to include unnamed rights under the category of a named fundamental right, and in that way by giving them the status of fundamental right. So according to Supreme Court, it is like this, that it is not enough that the right claimed by the petitioner flows or emanates from the named fundamental right, or its existence is necessary to make the exercise of the named fundamental right more meaningful and effective. And every activity which facilitates the exercise of a named fundamental right is not necessarily comprehended in that fundamental right. So what are the other factors? What are the important factors to be considered while construing the meaning of either right to life or right to personal liberty? Now this stanza is very important, that what is necessary to be seen, and that is the test which must be applied, whether the right claimed by the petitioner is an integral part to the named fundamental right or not. So unnamed right must be an integral part to a named fundamental right, that is either right to life or right to personal liberty. Second, the named fundamental right carries with it same basic nature and character of a named fundamental right, that is right to life or personal liberty. And third important point is that the exercise of the unnamed right is actually, in essence, in reality and in substance, is nothing but an instance of the exercise of the named fundamental right. So by applying these three criteria, Supreme Court in Maneka Gandhi versus Union of India judgment it's a 7-judge constitution bench, comes to the conclusion that right to go to abroad is an integral part to right to liberty, right to personal liberty, it carries with it same basic nature and character of named fundamental right, that is right to personal liberty, and in substance and in reality it is the exercise of the named fundamental right, that is right to personal liberty. In the language of the court, it is stated like this: the right to go abroad, and in particular to a specified country, is clearly right to personal liberty, exercisable outside India, and so it has been held in Satwan Singh Shahani versus Assistant Passport Officer to be a fundamental right protected by Article 21. Again, right to go to abroad is a highly valuable right, which is a part of personal liberty, an aspect of the spiritual dimension of human beings, and it should not be lightly, unconstitutionally interfered with. So in that way, we have got unnamed right to go to abroad, as a fundamental right under the category of right to personal liberty. It is a interpreting right. So basing on the ratio decidendi and by following the criteria as developed by 7-judge Constitution Bench in Maneka Gandhi versus Union of India, we have got umpteen number of unnamed rights getting the status of fundamental right. Now in the language of another larger bench of Supreme Court 9-judge Constitution Bench in case Puttaswamy versus Union of India, it is stated like this, that Article 21 has been interpreted to include a spectrum of entitlements. The rights which have been held to flow out of Article 21 include, like take for example Francis Corali versus Union Territory of Delhi, right to dignity has been declared as integral part to right to life. So right to life includes the right to live with human dignity and all that goes with it. Secondly, in Olga Tellis versus Bombay Municipal Corporation, Supreme Court has said that right to livelihood also is an integral part to right to life, and it's a protected fundamental right. So, in the language of the court, an equally important facet of right to life is that right to livelihood, because a person cannot live without the means of living, that is without the means of livelihood. So, in that way, another, like take for example, M.H. Hoskot versus State of Maharashtra, we have got legal aid as a fundamental right guaranteed under Article 21. Now, Hussainera Khatun versus Secretary State of Bihar, we have got speedy trial as a fundamental right under Article 21 Constitution of India. We have got healthy environment as a fundamental right under Article 21 Constitution of India in Virendra Gaur versus State of Haryana. We have got another fundamental right, that is freedom from torture in Sunil Batra versus Delhi administration. It is a fundamental right under Article 21 Constitution of India. Another important interpreting right which is covered by Article 21, that is right against custodial violence. It is declared as a fundamental right in Sila versus State of Maharashtra. So in that way, we have got right to reputation as a fundamental right under Article 21 Constitution of India in Subramaniam Swamy versus Union of India. We have got right to get medical assistance as fundamental right under Article 21 Constitution of India in Paramananda Katara versus Union of India. Now finally, whether there was a constitutional confusion, whether the right to privacy means leave me alone, don't encroach into, don't interfere, don't peep in, leave me alone, I will decide what I am supposed to do, I like to do. You are not here to interfere. So this right to privacy, whether it is a fundamental right or it is not a fundamental right, in that way a larger constitution bench was constituted, and the Justice K.S. Puttaswamy retired versus Union of India, Supreme Court unanimously categorically has announced that right to privacy is a valuable fundamental right under Article 21 Constitution of India within the purview of right to life. So in the language of the Supreme Court by a larger constitution bench, K.S. Puttaswamy versus Union of India, it states like that: life and personal liberty are inalienable rights. Secondly, right to life and personal liberty are not the creations of the Constitution, as I told you earlier that it is a primordial right. About right to privacy, the larger constitution bench says, Privacy is a constitutionally protected right which emerges primarily from the guarantee of life and personal liberty in Article 21 of the Constitution. Elements of privacy also arise in varying contexts from the other facets of freedom. And finally, unanimous view of the Supreme Court that the right to privacy is protected as an intrinsic part to the right to life and personal liberty. So, right to privacy is an intrinsic part not only to right to life, but also intrinsic part to right to personal liberty under Article 21 and as a part of the freedoms guaranteed by Part 3 of the Constitution. So, it is also an integral part or intrinsic part to other like right to freedom also. So, this is one part of our discussion. Second point of discussion, that was procedure established by law. What does it mean? That the question was already raised. Now, the Constitution Bench judgment, A.K. Gopalan versus State of Madras, that is considered as the high water mark of Indian positivism. So, the Supreme Court Constitutional Bench declared that there was no such rules of natural justice to be there in case of that procedure established by law. So, it means that the Constitution has given absolute right to the legislatures to find out the process and content of procedure established by law. So, legislatures have the final word according to the Constitution, and it is not the botheration of anyone to find out the rules of natural justice, fairness, justness, goodness or reasonableness. So, in the language of the court, by adopting the phrase procedure established by law, the Constitution gave the legislature the final word to determine the law. Now, by overruling the judgment in Maneka Gandhi versus Union of India, a 7-judge Constitution Bench has declared that the procedure contemplated in Article 21 must answer the test of reasonableness in order to be in conformity with right to equality, that is Article 14. And the procedure established by law must be just, fair and good, and not in any way oppressive, whimsical or arbitrary. If it is, then it would not be a procedure at all, and the requirement of Article 21 would not be satisfied. Now, let me appreciate Justice Fazal Ali. He gave a dissenting view in A.K. Gopalan versus State of Madras. According to Justice Fazal Ali, 4 essential elements which are written in Professor Willey's book on constitutional law, these 4 essential elements must be there to make the procedure established by law legal and constitutional. He was talking about notice, opportunity to be heard, that is adi alteram partem, impartial tribunal, that is nemo judex in causa sua, and ordinary course of procedure. Now, in the language of noted jurist Justice V.R. Krishna Iyer in Maneka Gandhi versus Union of India, so while commenting about the procedure, nature and content of procedure established by law, Justice V.R. Krishna Iyer says that procedure in Article 21 means fair procedure, not a formal procedure. And secondly, the law is reasonable one and not any enacted piece of legislation. Now, third point, that is the interrelationship between different fundamental rights. Take for example, by invoking or for the furtherance or keeping in view the constitutional requirement, a law is enacted or any administrative decision has been taken. So, obviously, it is absolutely fine with that particular fundamental right. But if you apply the direct and inevitable test, then you will find out, or we might find out that this particular administrative decision or that law is violating other fundamental rights, though not violating a particular, though obviously in absolutely in consonance with one particular fundamental right. So, whether each administrative decision or each law must satisfy the requirements of all the fundamental rights to make it a constitutional, to make it in conformity with the Part 3 of the Constitution, that is fundamental rights. Now, again, the high water mark of Indian positivism, A.K. Gopalan versus State of Madras, the doctrine of exclusivity was propounded, and it says that there is no such interrelationship between the fundamental rights. Each fundamental right has its own domain, has its own periphery. Now, by overruling this doctrine of exclusivity, the Supreme Court, a 7-judge bench decision in Maneka Gandhi versus Union of India, Supreme Court says that if a law depriving a person of personal liberty and prescribing a procedure for the purpose within the meaning of Article 21 has to stand the test of one or more of the fundamental rights conferred under Article 19, ex hypothesi, it must also be liable to be tested with reference to Article 14. So, each administrative decision, enacted piece of legislation must satisfy the tests of the requirements of all the fundamental rights. So, in the language, very brilliantly, Justice noted jurist V.R. Krishna has explained this. He says that no article in Part 3 is an island, but part of a continent, and the conspectus of the whole part gives the directions for construing or interpreting or finding out the periphery or horizon of a particular fundamental right. So, all fundamental rights are interconnected. Each administrative decision, each enacted piece of legislation has to satisfy the requirements of all the fundamental rights because all are interrelated. Now, finally, there was the dark phase of Indian democracy, and a very famous case that is also considered as second highest mark of Indian positivism. The issue is that whether the fundamental rights can be suspended, and even all the fundamental rights are suspended during emergency, whether right to life and personal liberty, these two fundamental rights also can be suspended. So, majority of the judges in ADM Jabalpur versus S.S. Shukla, majority of the judges, they have taken the decision that yes, even during emergency, national emergency or in any emergency, all fundamental rights can be suspended. The suspension of fundamental rights is purely legal and constitutional. Even the state can suspend from the operation, suspend the right to life and personal liberty also. Now, Justice Mahajan, he gave a dissenting view. And what the dissenting view, what he gave that in that judgment in Maneka Gandhi versus Union of India, that has been accepted. No, sorry, in K.S. Puttaswamy versus Union of India, a 9-judge constitution bench says that that judgment, the ratio decidendi, that the suspension of fundamental rights, including right to life and personal liberty, basically right to life and personal liberty, that is decision is absolutely wrong, and this 9-judge bench constitution bench decision judge bench has technically overruled that the ratio decidendi of ADM Jabalpur versus S.S. Shukla. Now, point is that by giving dissenting view, Justice Khanna paid the price for that. So, he could not, he was not made the Chief Justice of India. Otherwise, we could have got one of the finest judges as Chief Justice of India. But his contribution for upholding the democracy and for protecting for even at the cost of his career, for protecting democracy, for protecting and safeguarding the valuable fundamental rights, for that reason we all Indians are very grateful, thankful, and we are very indebted to him. Though he was not made the Chief Justice of India, but he is the Chief Justice of India in the hearts of each and every individuals of this country. Even he is the Chief Justice because of his selfless service and a kind of courageous, by showing courage, by showing boldness, the way he wanted to protect the Constitution, the fundamental rights. That is also kind of, it is the people of the world citizens are also very much thankful and grateful to Justice Khanna. So, nowadays, after that judgment came into being, though there was a constitution amendment, and by making the constitution amendment, it was made in that way that during emergency, right to life and personal liberty could not be curtailed, but it was there in the ratio decidendi. So, that was technically overruled by a 9-judge bench, constitution bench decision, K.S. Puttaswamy versus Union of India, that it was wrong, and as a result, it has overruled that decision of ADM Jabalpur versus S.M. Shukla, that fundamental rights, that is right to life and personal liberty, cannot be suspended. At present, even during emergency, right to life and personal liberty cannot be suspended. So with this, I conclude this part of discussion. Thank you so much. It is the victory of the democracy and victory of the people of India, and victory of the people who are fighting everywhere in the world for fighting for justice, fighting for the realization of valuable fundamental rights, which are basic human rights and inalienable fundamental rights. Thank you so much.